lay my hands on one, my lord, such declaration. I'll just, my lord, place it for your lordship's consideration, because because of paucity of time, other governors, my lord, I could not reach. But governor of Manipur, my lord, has sent me, because there was one bill which was withheld. Same, nothing turns on that, but my lord, there was no political difference, my lord, between the center and the state, but there was, my lord, this bill. Your lordships need not read the bill; it's not relevant. Manipur agricultural produce and livestock I'm sorry.
I withhold assent from this bill.
Agricultural produce, livestock marketing, so and so. My lord, the reasons are given in the file notings. My lord, and there are also exchange of letters, calling the chief minister, calling for some details, etc., etc. But ultimately, my lord, then governor says, I withhold assent from this bill. So there is a declaration made, my lord, just to answer your lordship's question, my lord. Second, my lord, I'm told that so far as the number of the act is concerned, if it is returned under the first proviso and sent back with or without modification, if that happens in the same year, then the same number continues. If it happens in the next year,
New number, yeah.
then new number, my lord. But there is something, my lord, on.
No, but in any event, when it goes back, it is confined only to that question and nothing more.
My lord,
So the House will deliberate on the question that the governor has asked the
My lord.
court to the House to reconsider. It will be confined to that and then returned back. And in fact, many assemblies have made rules saying that there shall not be
any other discussion. Even Parliament has that
Yeah,
rule.
all the-
I'm sorry, my lord, Lok Sabha, Rule 132. I'll just read, my lord, and then I'll take my written submissions further. The debate on such a motion shall be confined to consideration of matters referred to in the message of the President, or to any suggestion relevant to the subject matter of amendments recommended by the President. So,
November Arabia also talks a little bit.
yeah,
about
yes, my lord, we could find out, my lord, some legislative, but the position is virtually same, my
They
lord.
are far ahead of us.
Yes.
But we as lawyers seem to think that,
No, your lordships are far ahead. Your lordships have.
I'm saying the assemblies,
No, my lord, constitutional framers were far ahead of us.
definitely.
But they could foresight, my lord, their foresight was, my lord, salutary. Yes, my lord, my learned friend, my lord, Mr. Maninder Singh wants me to say, and very rightly, that the language itself says, provided further that governor shall not so and so, in his opinion, it would reconsider the bill accordingly. So that accordingly restricts the scope of discussion. You cannot start a new discussion. It would be only confined to the message, potential amendment, etc. Now, my lord, if your lordships can take, my lord, my written submissions, and my lord, between the two of us, we'll try and we will conclude, my lord, before 1 o'clock, my lord. Try and conclude was a wrong expression, or loosely used.
We'll be grateful to you.
Pardon, my lord?
We'll be
No,
grateful
no,
to
no,
you.
but there is no point, my lord, in boring, my lord. At some stage, the courts are also saturated, my lord. We feel that we still want to bring our case home, despite knowing that rightly or wrongly, our submission has reached there, my lord, whether it's in my favor or against him. Lord, please come to page 767. This is a new point, my lord, I'm beginning with. The point is, my lord, other side, the learned councils, my lord, relied upon Article 213 to substantiate their interpretation. Seven, 6, 7, para 49. Lord, the argument was based upon Article 213. The interpretation which was canvassed by my learned friends, my lord, the learned council, was that this clearly shows that there is no discretion in the governor. Lord, as a matter of fact, Mr. Datar went to the extent of saying, and I, my lord, as a constitutional interpretation, seriously object, that legislature has a right to pass even a void bill. It will have to be assented to, and only your lordship can set it aside. So,
That's their argument.
yeah. So there is no option. Governor has not, forget 3 or 4, that's not the debate. There is no option at all. Then why have the governor at all? That's the simple argument. But, my lord, one of the argument was that promulgation of the ordinance, please see, my lord, the language used. I'll read, my lord, whatever is necessary, and I'll skip what is, my lord, already either orally paraphrased or earlier argued. If at any time except when the legislative assembly of a state is in session. So if the assembly is in session, no ordinance can be issued. Simple. Or where there is a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinance as the circumstances appear to him to require. But I am not saying that read discretion here. It has to be his discretion. There is no doubt about it, but that's not my submission. That's not the only submission.
No, but
Provided that.
his satisfaction or the satisfaction rendered on the basis of the aid and advice of the Council of Ministers.
Therefore, I am saying it is not, my lord, my submission that it is his.
Normally, the ordinance making power is of the executive.
I am not disputing that. Therefore, I said that that's not my submission. I preempted, my lord, that it has to be as per aid and advice. But there is a discretion even after aid and advice. That is what I want to show. Provided that the governor shall not, the constitutional prohibition, without instructions from the president, promulgate any such ordinance if, kindly come directly to B. Lord, please read A first, Lord, so that it can be read in context. A bill containing same provisions would, under this constitution, have required the previous sanction of the president for introduction thereof into the legislature, like Article 30, 31, etc., etc., my lord. B is very relevant, my lords. He would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. If it would have been a bill, he would have considered it necessary, despite aid and advice given to him by the Council of Ministers, that no, this needs reference to the president. I must refer it to the president for his assent. Now, please see, my lord, see, an act of legislature of a state containing the same provisions would, under this constitution, have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. So, like Article 254, 254(2), the repugnancy. There is a repugnancy. So here, my lord, it makes it very clear that the framers of the constitution says that in the first part, yes, you will act as per aid and advice, as my lord, the Chief Justice very rightly pointed out, but he shall not do it if these three contingencies, and one of the contingencies be, he would have deemed it necessary. When the bill comes to him, he would have deemed it necessary to reserve the bill containing the same provision for consideration of the president. In that case, he needs prior instruction from the president in case of an ordinance. Now, please come to para 51. It may be pointed out that Article 213, page 767, para 41, 51. It may be, it may be pointed out that Article 213 is a power to promulgate ordinances. The ordinance is promulgated by the governor himself. Subclause B will have to be read in the context. In view of the nature of the ordinance itself and the fact that the governor is promulgating the ordinance, the question for the grant of assent, first option under Article 200, will not arise, because ordinance, there is no question of granting assent. He himself is promulgating the ordinance. Similarly, second option of withholding under Article 200 will also not arise. The assembly not being in session is the precondition for exercising the power of promulgation, and therefore option of returning would not arise. Thus, there is only one option for the governor out of the four options mentioned in Article 200, and that is referring the bill for the president's assent. Now, my lord, this provision came in for consideration before a 7-judge bench of this honorable court, my lord, which was not cited till date, my lord, because this Article 213 argument came, my lord, orally in the and in written submissions also in the reply. Therefore, I am, my lord, respectfully urging the counter. I'm not in rejoinder. This is how the central government interprets the constitution. Please come to, my lord, Krishna Kumar 768. In Krishna Kumar Singh versus State of Bihar, a 7-judge bench of this court held as under. My lord, then 231 is quoted. I am skipping that. The first of the above condition arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade, commerce, or intercourse with or within the state, notwithstanding anything in Article 301 or 303. The proviso requires the previous sanction of the President before a bill or amendment for the purpose of Clause B can be introduced in the state legislation. An illustration of second requirement, that is point 2 above, my lord, point 2 where B, my lord, is provided by Article 200 of the Constitution, under which the governor is required to reserve for consideration of the President any bill which, in his opinion, would, if it were to become a law, derogate from the powers of the High Court so as to endanger the position which it is designed to fill by the Constitution. Situations where the assent of the President is required, then point 3 above, are illustrated, my lord, 254, etc., my lord, where he will have to refer it to the President. There is a clear repugnancy, my lord. That's what the court said. Illustrated by Article 254, where a law made by the state legislature on a matter enumerated in the concurrent list of the 7th schedule is repugnant to a law made by Parliament, the state law will prevail only if and to the extent to which it has received the assent of the President. These three situations make it abundantly clear that while exercising the power to promulgate an ordinance, the governor is not liberated from the limitations to which the lawmaking power of the state legislature is subject. So, my lord, as a matter of fact, Article 213 aids my interpretation that despite there being contrary aid and advice, the governor has the room for discretion. So that's the respectful submission supported by, my lord, a 7-judge bench judgment, my lord. And I have, my lord, now given the contingencies for such reservation over and above the express clauses under the Constitution cannot be illustrated exhaustively, but may depend on the following factors. My lord, please pause here for a minute. My lord, I have cited in my initial respectful submissions and even during these submissions that there are judgments which says that irrespective of constitutional provisions, there are discretions available, calling the minister, calling someone to form the ministry, etc., etc. Lord, in none of those cases, in all those cases, the Supreme Court was very clear that these are only illustrative and not exhaustive. Because the Supreme Court was very clear in my submission that there may be circumstances which may arise in future where, other than the illustrations which we give, the governor may have to exercise his discretion. I'll come to that. But I have given, my lord, the broad parameters within which, my lord, he will have this discretion, where the bill is capable of subverting the Constitution. Nobody can dispute this, my lord. Where the bill is undermining the Constitution. Where the bill erodes the principles of democracy. Where the bill is of such a character that it has a national implication. Lord, Therefore, my lord, I have gave an example of Punjab water dispute. My lord, 4 states involved, Punjab, Haryana, Rajasthan, Delhi. There was an international treaty with Pakistan. And one assembly said that we revoke the agreement entered into. And my lord, now we are faced with an argument that you have no option. Even a void bill, you will have to grant assent to.
This court granted stay of that.
Yes, obviously, my lord. But my lord, that would not take away the power of the governor. My lord, kindly, my lord, appreciate. Your lordships are right. Your lordship stayed it. But that would not have taken away the power of the governor also to withhold. That you can't do this. This affects the federal structure. 4 states are affected. The center is affected because there is an international treaty in place. My lord, then, my lord, second submission, my lord, which I have made, but I wish, my lord, some of the judgments to be only relevant parts to be shown. My lord, I gave certain examples, my lord, that suppose the assembly passes a law that we will have a separate force. They may not term it as an army. That would protect the borders of my state, for example. Or a person belonging to a particular community will not be permitted to have any trade and business. These are extreme examples. Now, my lord, this section of my written submission deals with, then in past also, Supreme Court has dealt with extreme examples while interpreting Constitution of India. Because what your lordship decides today will be the foundation as to how the country will govern, number one. Number two, the Constitution will have to be interpreted with the harshest of the examples because it will have to withstand the test. There are many acts which are passed today which possibly would not have been contemplated, my lord, 70 years back. Now, please see, my lord, I have given the example of Lord Nani Palkhiwala giving extreme examples that somebody surrenders the sovereignty, takes away the right to vote from a particular class of persons, or confers right only to a particular class of persons. Somebody say, my lord, some government come out with a say, as a, my lord, cheap publicity gimmick, that we will not tax anyone except some industrialists. These are not, my lord, these are, my lord, possible potential examples. Supreme Court has examined extreme situations. Please come to page 771. Lord, in Keshwanand Bharti, only I'll read the highlighted part. Lord, if this is so, Lord, please see the extreme examples which are tested. If this is so, a political party with a 2/3 majority in parliament for 4 years could so amend the constitution as to debar any other party from functioning, establish totalitarianism, enslave the people, and after having effected those purposes, make the constitution unamendable or extremely rigid. This would no doubt invite extra constitutional revolution. They have considered that if we interpret it in a manner, this kind of bills also can be passed. Mr. Palkhiwala gave an example that suppose Article 368 is amended, conferring power to amend on the executive, that henceforth the government will amend the
Because
constitution.
these observations
Yes.
are in response to the argument that the parliament's powers to amend the constitution are unbridled. So, rejecting that argument, these observations have been made.
I'm sorry, I'm